Hello, everyone. Welcome back to another episode of the Divorce Differently podcast. In today's episode, we're tackling another very common divorce myth, the idea that if your ex behaved badly during the marriage, you'll automatically receive a bigger share of the assets when you divorce. It's a belief that a lot of people hold that when they're going through separation, they believe that if their ex has been unfaithful or dishonest or has behaved poorly, it can feel really unfair, but that they think that it has an impact on the financial outcome. Unfortunately, the reality on the ground is very different, and how the finances are decided and split upon divorce is often quite different to that. This episode is part of our Debunking Divorce Myths with Gilson Gray series, where we unpack some of the most common misconceptions about divorce and compare them with what actually happens in practice. So today we're going to explore where this myth comes from. We're going to explain a little bit more what the law in England and Wales actually says about conduct and how it impacts the division of assets in divorce. So to talk about this, I've invited Sharan Bhinder-Dhonsi. Sharan is a legal director at Gilson Gray's family law team in London, and she's been practicing exclusively in family law since 2009. Sharan specializes in divorce, financial settlements, and the protection of the most vulnerable spouse. Sharan, thank you so much for joining me.
Hi, thanks for having me. It's nice to be back.
So I think in this conversation, we kind of need to draw a line in the sand in pre-2022 and post-2022 and what changed at that stage. Could you tell us a little bit more about no-fault divorce and how that changed the impact of people's behavior in division of assets?
Cool. So initially, conduct was relevant in terms of the divorce. So, there were various different facts they had to rely on. One of the most commonly used one was obviously adultery.
Hmm.
So obviously people would come in and say, unfortunately, obviously my spouse has been unfaithful, and I'd like to use that as a reason to divorce. And obviously at the
Yeah.
time you could do that. That was your reason. However, what was usually expected with that was that because the spouse had been unfaithful,
Hmm.
that there would be some form of punishment in terms of the
Yeah.
finances. And unfortunately, that was just never true. It wasn't true at the time. And obviously, since that, we're now in what's formerly known as the no-fault divorce. And so, in the current situation, you can't even really raise a
Yeah.
spouse being unfaithful. And obviously, on a personal level, it's very clear to understand why some people feel that is unfair.
Mm.
That when the marriage has broken down, if they feel it is entirely the other person's conduct that has led to that, they want that to be a relevant factor. But
Yeah.
unfortunately, within the divorce process now, it's not. In order to proceed with divorce, you simply have to state that you agree the marriage is broken down. The court does not even ask the question why or how that breakdown has happened. Um, and whilst that can be difficult for some people, the reason that change was made was actually to make the process easier.
Hmm.
For people divorcing. Historically, when you did raise adultery, you still had to prove that adultery, and actually the
Yeah.
evidential burden was very, very high.
Hmm.
So it was not sort of a case of just being able to say, I think this person, or I suspect that my spouse has because he's
Yeah.
been staying out late for work or spending a lot of time with the individual person. The reality on the ground was it was a really expensive process. We were having to instruct private investigators to follow people to try to get evidence. And so it was actually a very difficult process. And I think it didn't help anybody in terms of negotiating the financial settlement. I think it
Yeah.
encouraged people to spy on the other spouse to try to find reasons for the breakdown. So I do think the move towards no fault divorce it is better for the parties ultimately. I think it helps parties move on, and it
Yeah.
really shifts the focus as well on the future rather
Yeah.
than what has gone on previously. So I think that change has been a positive one, although I understand it can be difficult for clients sometimes when they want some sort of evidence or some sort of recognition or acknowledgement
Yes,
that one
exactly.
party has behaved badly.
Is that sense of emotional justice, right? That it's their fault, so they should be the ones suffering the consequences of the breakdown of the marriage.
Exactly.
And
Um,
so are there circumstances where it would be taken into account? What kind of behavior would that require to have an impact?
Well, the things in terms of the finances, if we're looking at the Section 25 criteria, I'm not going to get too technical, but one of the factors the court can consider is conduct.
Yeah.
So it is true to say that a party's behaviour during the marriage can have a financial impact. But as you sort of said in the introduction, the important thing to note is that it is not automatic. And
Yeah.
even when we're looking at, whether any conduct will be relevant, again, the threshold is quite high. Interestingly, recent case law has suggested slight movement
Yeah.
in that respect. So historical position has always been that unless there was a direct financial consequence
Yeah.
of a party's behaviour, and unless the party's bad behaviour, if we can call it that, was exceptional, it generally wouldn't be considered relevant by the court. So, for example, domestic abuse, and a lot of
Yeah.
people were surprised about this, but domestic abuse generally was not considered to be a relevant factor when looking at a financial split. And again, a lot of people will disagree with that view,
Yeah.
and would say actually if domestic abuse has been present, then there should be a consequence for that, because inevitably that would have affected the victim in that case. But generally that wasn't the done thing. The only sort of cases really where conduct would be considered, for example, would be if there had been a case where a father had, for example, sexually abused a child, or something very exceptional. For example, if all the family assets, or majority of them, had been gambled away, something like that.
Yeah.
Or obviously if a party was attempting to dissipate assets, so transfer all the assets to a sibling or a parent, something like that, where there was I'd say a really obvious financial connection,
Yeah.
that's when a court would look at conduct. But even then, the evidential threshold has always been really high. So it's
Yeah.
never been enough to sort of just say, oh, I believe this has happened. If you
Yeah.
were going, for example, allege that money has been moved somewhere else, you'd have to really get the evidence to show where it was originally and where it had gone, and and the judge would have to be persuaded that that had taken place. But in recent case, what has now happened is a judge has accepted, and I'll go into a little detail about this particular case. The circumstances are quite unusual. So again, I think people have to appreciate that each case will turn on its facts.
Yes.
But in this particular case, I think one of the reasons that the judge did actually make a fairly significant reduction, actually, in the wife's share of the matrimonial assets, was because it was considered that her conduct
Yeah.
was so deplorable that it would be inequitable to ignore it. And within that conduct, there are actually various arms. So she had been abusive
Yeah.
to the husband, and there was evidence of not only controlling coercive behaviour, but also physical violence. So that aspect was actually considered by the court, which is fairly new.
Yes.
But I think what assisted the judge in being able to say that a threshold had been reached was that there was obviously clear also evidence of financial abuse. This was a situation where the wife had, by lying to the husband, by emotionally manipulating him, by blackmailing him in some occasions, and in other settings, I think it was actually, fraudulently removed funds from the husband. And
Yeah.
what helped in that case was that there was clear evidence of this. You could see the money being transferred.
Yeah.
There was third-party objective evidence to support that fraud
Yeah.
had been committed by the wife. So there was criminal case. There was police evidence. So all those things help. And another important part is that there has to be a link between the behaviour and a financial consequence. So in this
Yes.
situation, the wife's controlling behaviour, the wife's dishonest conduct had direct financial implications for the husband, because he had given wife lots of money based on the dishonest things that she had said to him.
Yeah.
So in that case, the judge considered actually the threshold had been met, the link was clear, and a reduction was made accordingly. So I think that is good news, because I think it shows that the court is now perhaps more willing to make a judgment and to reduce potentially
Yeah.
a spouse's entitlement where there is clear evidence
Yeah.
that there has been exceptionally bad behaviour and there is a link between that and a financial consequence. And so I think that's what the important part to understand. Unfortunately, the court is not, or at least not in the judgment we've had yet, saying that if there is domestic abuse, a reduction will be made for that behaviour.
Yeah.
But the court is saying that perhaps the court needs to have a more holistic view when they're looking at behaviour, and actually maybe behaviour should not be just immediately dismissed as having no financial implication. And, we have to, I think the point for the judge was that I think judges have to be a bit more open to really considering, is there actually a link between behaviour and finances? And I think most
Financial
people would
complications,
agree,
yeah.
yeah, where there's controlling coercive behaviour, I think there is likely to be a connection. Financial
Yeah,
abuse is very
oftentimes they go
common.
hand in hand. Yeah,
Exactly. So I think we probably will see a link. So in terms of, from a lawyer's point of view, we are sort of waiting to see what other judgments now come out following that. But
yeah,
I think that does potentially show that might be opened up in terms of more conduct may be considered. Um, but again, I say, but the important thing to stress is there has to be a link, and again, there has to be evidence. In this case,
mm,
because there were criminal proceedings and there was
yeah,
evidence of her fraud, all of that helped put together a picture. If it had been a situation where it was just one party alleging that abuse against another, I don't think we necessarily would have got the same result as in
yeah,
that case, just because evidentially that threshold wouldn't have been met.
yeah,
And I think the other important thing as well also to note is that if a party is going to plead conduct, so if a party wants to raise the other party's behaviour as a relevant factor in financial proceedings, it has to be done as soon as possible
yeah,
during the Form E stage.
yeah.
Because, that's
And
nothing
there is a
sometimes.
box there, which a lot of people get confused about because I've seen several people drafted saying, yeah, she yells at me or he lied to me.
Yeah,
And because it's an opportunity to actually say get that moral
we
justice,
think.
but actually that's not what it's about, is it?
No, and I'm not just for me, like most legal forms, it's not the clearest, but like you say,
Yeah,
there is a specific box on the Form E, and what it actually is relating to is behaviour. So that's for people who are alleging that the other parties behaved in such a way that it actually should not be ignored by the court,
yeah,
and there should potentially be financial implications for that person. So it is really important, if you want to plead conduct, to have that discussion very early on with your lawyer so you can understand, is that case likely to be successful? Is
yeah,
there evidence to support? Is it
yeah,
going to be relevant? Because the other issue is, if a party pleads conduct, but then actually it transpires that there isn't evidence in support, or that there is actually no link between
yeah,
that behaviour and the finances, but the court has obviously spent more time investigating that aspect of the case,
yeah,
the person who made that raised the conduct could actually be hit with a costs order, which means
yes,
there could be an order to pay the other party's costs. So it's, again, it's not an easy thing to plead, and it's something I think people have to think really carefully about as to, A, are they going to meet the threshold? Is the behaviour going to
yeah,
be relevant? Is there that link with the finances? But also just in terms of moving forward, is raising conduct going to help them resolve matters? Because in some situations, if potentially you could run a case, you have to also think about the damage that's going to do in terms of the relationship between the parties, especially if there are young
yes,
children, or if the parties are hoping, for example, to negotiate and settle at an
yeah,
FDR. It's unlikely to be helpful to negotiations to
yeah,
raise it. But in terms of a strategy, sometimes what we do is, if conduct could potentially be applicable, we will put it in the Form E. But as
hmm,
part of negotiations, you can actually agree with the other side that you won't pursue it. So that's also
okay,
an option. And because it can be difficult to raise conduct once you've gone past the Form E stage. So I
yeah,
would say, it may be worth putting it in on the basis that you can obviously then agree something else with the other side. But it should never be put in, like you say,
yeah,
just to get that emotional justice. That's not what it's for, unfortunately. And then you can get criticised by a judge for incorrectly pleading conduct.
yeah. And I guess another example, to come back to your earlier example around adultery, would be if a spouse is buying very expensive jewelry or going on very expensive trips with their mistress or a lover. Those would be the kind of things where, again, you'd have to evaluate the threshold with your lawyer. But because there's that link between the behavior and the finances, there might be a case to be made.
Exactly. If there is clear evidence that money, what would be matrimonial money, family
Yeah.
money, is being spent elsewhere, and
Mhm.
like I say, to be relevant, they would have to be fairly significant sums.
Yeah.
And then there is a case, because obviously then there is a case potentially to plead for what we call an add back.
No,
So
yes,
let's
exactly.
say, yeah, the husband has spent, I don't know, £100,000 buying mistress a holiday home in Spain or whatever it may be. I mean, that would be a significant enough sum to pursue an ad back on the
Yeah.
basis that family money has gone out, that, without the other party's consent or knowledge.
Yeah.
So it's definitely worth having a conversation. But as we've said, really the relevance is only to finances now, rather
Yes.
than the divorce itself. And it really will come down to the evidence and the financial link. Judges generally take a view that if a marriage is broken down, there will be bad behaviour.
That's
Perhaps
true.
only by one spouse or by both
Yeah.
spouses. So it's important to know that unfortunately judges are not overly sympathetic, I would say.
Mm.
Um, just sort of what we would deem general bad behaviour, like you said, a verbal argument, or just not sharing things on when you're removing the family car, whatever it may be. If it's not of significant financial value, the court will usually take a view that it's not worth the court's time,
Yeah.
unfortunately, just
Yeah.
because they're so backlogged to spend a significant amount of time dealing with an issue unless there is a significant financial consequence from it.
That makes a lot of sense. And so one thing that sprung to mind is, I don't know whether that's something that gets done a lot in the UK. I've never seen it, but in the US, it's quite common for people to put a clause in their prenup along the lines of, if you were to cheat, I would get X amount of money, or if, whatever the behavior might be. Is
Yeah.
that something that can be done, and how do the courts see that kind of clause?
Things, well, we are seeing, I'd say, definitely much more creative clauses in prenuptial agreements, if I can put it
Yeah.
that way. And I'd say the way that it works is if both parties agree with that clause
Hmm.
and that prenuptial agreement is never challenged,
Yeah.
then that would be fine, because that's an
Okay.
agreement between two parties. Everyone's had legal advice, everybody agrees. But I
Yeah.
think you may run into trouble, for example, if such a term was taken to court and challenged, because ordinarily adultery is not something that is punished under English law. But of course,
Yes.
if both parties have had legal advice and they agreed to those terms, a court could make the choice to enforce that, or a court may take a view that actually that goes against what a public policy in terms of punishing a spouse.
Yeah.
But I am seeing similar terms in terms. I think it's a fairly sort of new social media trend in terms of payments for having children, which again is something
Oh, yes.
historically we didn't really see. Again, I think that has come from the US. But yeah, I think it's called push money. I have had that in several agreements as well.
So you get a certain amount of money based on how many kids you produce out of the
Yes,
marriage.
per
Okay.
child, exactly.
Yeah.
And again, that's not something under the English or even the court system that would ever be discussed. But again, in a prenuptial agreement, if that term has been included, everyone's had legal advice and everybody agrees, there's no reason really why you couldn't include such things. I've just
Yeah.
done a prenuptial agreement recently, actually, that deals with, and again, it's quite similar in terms of what we're talking about, the conduct and financial consequences, in terms of any debt that is
Hmm.
accrued without the other party's knowledge,
Yes.
in terms of there will be financial consequences for essentially behaving in a financially irresponsible manner. So I
Yes.
think so. I think we are seeing a lot more now of people sort of trying to include a catch-all, really,
Yes.
and
To
part of
protect
that probably
themselves.
is, yeah, and it probably is because under the English court system, there's such limited space to do that. But like you say,
Hmm.
a prenuptial agreement, postnuptial agreement, even a cohab agreement is potentially a space where you can do that and put in the
Yeah.
terms that are relevant to you to try to kind of monitor or punish that behaviour.
Yeah.
If the relationship were to break down.
So what I'm really hearing from you is that the courts are not interested in moral justice here. They're not looking at judging
Fortunately,
people's behavior for the nature of that behavior. It's only in as much as it impacts the finances, and the threshold's actually quite high for it to be considered.
it is. So the court will only relook at conduct if it's considered inequitable to do so, to
Yeah.
ignore it.
Yeah.
So that's why it still does have to be quite exceptional. But like I say, I think we may be seeing a change in that.
Yes.
Um, which I think would be a good thing. Like you say,
Mhm.
I think if you're looking at sort of from any non-legal person's point of view, they would expect that if somebody has behaved badly, if somebody has been abusive, that it would be reasonable to expect that there may be a consequence for that.
Yeah. Yeah, that's a
Um,
reasonable
but
expectation.
I think the court is very concerned about sort of opening the floodgates, just in terms
Yeah.
of, because the court has such little capacity as it is, and it's a shame that that may be one of the reasons it's kind of curtailed. But I mean, that's the system we're working with.
And I guess there's also a risk of kind of tit for tat, right? Where everybody starts calling out the other person's behavior. And the reality is that in any marriage breakdown, there's usually two dancers in that waltz, and none of the two is perfectly clear, and the other is all at fault. So
Well,
it
that's the thing as well.
can
And you can
overspout.
imagine, if they did open up the gates for conduct to be pleaded just generally for everybody without that high threshold, we could end up in a situation, like you say, where we've got statements of 20, 30 pages of all the terrible things one
Yeah,
spouse has done to the other over a 25, 30-year marriage.
exactly.
And given that most things are happening behind closed doors, it's unlikely there's going to be much evidence to support either
Yeah,
way. And that would just completely overburden the court of people. But also, it would really prevent people from resolving things and moving forward, because people
that's
would
it,
then
exactly
really get
right.
entrenched in their positions. That no, I'm right, the marriage breakdown was your fault, and rather than focusing on, okay, what do we need to move forward and be
Yeah.
independent, people would be focusing on proving
Yes.
that that it was the other party's fault, or that they were correct, or whatever it might be.
Which is again against the ethos of the no-fault divorce as well, in of itself, that we don't want to be blaming and pointing fingers. It's about resolving matters.
Exactly, and that is very much where we want, I think, the English court system to go towards.
Yeah,
How can we resolve this for people in a cost-effective, time-effective way? The last
absolutely.
thing we want is anything that is going to draw out the procedure even more, where
That's
there are
exactly right.
contested cases. Yeah.
So for those who think, believe, suspect that their ex has misbehaved in a way that would have financial consequences that might need to be raised, that would be a conversation then with their lawyer to kind of define that strategy as to whether it's worth even including it, whether it's worth raising it, or just focusing on resolution and just letting it go.
Exactly. I think conduct, because it's such a technical point,
Yes.
in the way that we'll look at it. I think it is very much something you would need to raise with a lawyer. I think it'd be really important to get all the evidence together. So if anybody who
Yeah.
did potentially want to, you'd need to have all the evidence together, so a lawyer could really judge what the chances of success were. And
Yeah.
also, again, given whether it's an amicable separation, or an acrimonious one, whether, like I say, strategically, it would be worth pursuing that. In some
Yeah.
cases, it is. If you're going to go to court anyway, because things are very acrimonious,
Yeah.
it may be worth pursuing. However, if there's a really good chance of an amicable resolution, then it may not actually be worth doing it. And like you say, that's one of the reasons the court got rid of the unreasonable behaviour, because it
Yes.
was
Yes.
leading to more contentious situations, because understandably nobody liked having 6 allegations about their terrible behavior during the marriage, and they were never accepted. Sometimes they were challenged with cross applications, and that's the sort of behavior the court's really trying to reduce.
Yes.
um, so I think it's
Which makes
conduct is
sense.
definitely something to discuss, before
Absolutely.
pursuing it.
Well, thank you so much, Sharon. I will put your contact details in the episode notes. So if anybody needs that kind of advice and is struggling to figure out, how their ex or soon to be ex's behavior might be taken into account, they can reach out to you and you can help them build that strategy really according to what they want to do going forward.
Yep, they can. They can go obviously onto our website. They've got my email details there. It's something we deal with quite a lot. So yep, I'd be happy to have that initial conversation, just so they can understand what their position is, and like you say, whether strategically that would be something worth pursuing.
Perfect. Well, thank you so much, Sharon. Thank you for sharing all this information, a lot of insights, and have a lovely day.
You too. Thanks now.